Chapter 2 introduces us to the law and the legal environment of business. From the book's perspective, they're focusing our study of legal environment on 5 key features. The first is critical thinking, which we were introduced to in Chapter 1. The second is legal literacy. The third, understanding that law is dynamic, it is not static, so that means it's constantly changing, constantly updating. The fourth is real world problems. So there we're faced with real legal and ethical issues. And the fifth is interdisciplinary in nature. And part of that is that many times judges and attorneys must consider information from various disciplines to make decisions. So it's important in the field of law to be well-rounded, to not just be focused on one particular thing, because you might need to utilize other areas of study to make appropriate decisions. Chapter 2 also introduced us to jurisprudence, which seems like we'll be talking about quite often. That is the science or philosophy of law. Law is defined in different ways, and it has 7 accepted schools of legal thought. Those are natural law, positivists, sociological, American realists, critical legal, feminists, and law and economics. So during this chapter, we went deeper into each one of those topics and to learn a little bit about each one and sort of the thought process behind each area for each different school. The chapter then goes on to introduce us to sources of law. So within the U.S. Constitution, there were created 3 direct sources and 1 indirect source of law. The 3 directs are legislative branch, which is the maker or creator of laws, the executive branch, which is the enforcer of laws, and the judicial branch, which is the interpreter of laws. And the indirect source of law are the administrative agencies. The chapter also gave an overview of the legislative process so that we could get a better understanding. Though some of us may have had a bit of understanding, I definitely think that this information really has forced us to look deeper into what the legislative process is all about. And then it also went into the various branches and talked individually about those branches and the makeup of those branches. Moving ahead to chapter 3, again, I felt like this chapter was just chock full of information. The chapter 3 really focuses on the American legal system, and we in America operate under a dual court system. Everyone is subject to state laws as well as federal laws. In this chapter, we really learned about the jurisdiction of the state and federal. We learned about the appellate jurisdiction, and then we really went into learning various components of the court system. So what the meanings are behind, who is the plaintiff, who is the defendant, what is a complaint, what is the definition of a summons, all of those kinds of things. I really did find this chapter very interesting. Took tons and tons of notes, so definitely a lot of information, but it really was interesting to kind of get a better look at what our legal system is all about, both on the state level and on the federal level as well, and where those two may cross over, and where the state system could then kind of intersect with the federal system. The chapter also talked about, like I said, the structure of the federal system, the structure of the state system. Each state might be a little bit different, so it would be important as a business person to look into what the structure is of your own state system if these situations that you are facing are going to be in the state system, which is probably pretty likely for most businesses. The chapter also went into what they called the actors in the legal system. So it talked about the attorney, it talked about the judge, it gave various information about each of those, the different types of judges, whether it's a trial judge or an appellate judge, what the definition is for a judicial review, the difference between judicial restraint and judicial activists, which I thought was another kind of interesting area, especially as we are presented with possible candidates for the U.S. Supreme Court, and sort of what their backgrounds are and what their veins of thought are, as those people are appointed for life as opposed to people who are elected officials. I did find it interesting, just as a side note, on some of the reasons why those U.S. Supreme Court judges are appointed for life, which is something kind of I always thought about, I guess, but never really took the time to look into. So I found that really interesting, that part of the reason why that is because it takes away their fear of kind of the repercussions for making certain decisions that may not necessarily be the popular ones. So I did find that interesting. Back to the actors within the system, we also learned a lot about the jury and whether it's a petit jury or a grand jury and sort of the difference between those two. The chapter talked about steps within civil litigation and the steps within a kind of the before a trial, and then during the trial, what the steps are, what the appellate procedure is, and a little bit, it talked about appeals to the U.S. Supreme Court, and realizing how very few cases there are that are actually heard per year at that level, and what the process is to actually have your case heard at the U.S. Supreme Court level, what the requirements are and what they're looking for when they're making those decisions about the cases that they plan to hear. And then further, as we kind of wound down the chapter, we learned a bit about class action and what class action lawsuits are kind of really about, what that means, what the Class Action Fairness Act of 2005 is, and what the makeup is of that, and why that act was actually put into place. And then finally, it talked about the global dimensions of the American legal system. And I think this is an important area for those who are interested in getting into international type business situations, to realize that when parties are making international agreements, they can incorporate as a term of their agreement which nation's court will hear disputes. And often, I think it's probably chosen for the American system to hear the dispute because of the structure of our legal system. Again, I found these chapters really full of information. I think that this is information that we'll probably be referring to as we move ahead this semester. It was a lot of information to read, take in, and digest. Some of it I at least was a little bit familiar with, and perhaps you were too, but I certainly wasn't aware to the depths that we went into this. And I think that it's probably important as a U.S. citizen to understand a little bit more than I have. So I look forward to continue reading as we look ahead to chapter 4.